of whether the exercise of power was mala fide or palpably irrational, Justice Reddy observed that the advisability and necessity of the action must be borne in mind by the President. 2. This bench, sitting in a combination of 5 judges, is bound by the decision of the majority in S.R. Bommai on the issue. We also undertook a textual and purposive reading of Article 356 in particular and Part 18 as a whole. We hold that there are limitations on the power exercisable after a proclamation under Article 356 is issued. The following are our reasons. First, the thread that runs through Part 18 of the Constitution, when read as a whole,
ये आपको बता दें कि जस्टिस चंद्रचूड़ का कहना है कि फैसले भले ही अलग अलग लिखे गए हैं, लेकिन एक ही निष्कर्ष पर सहमत हैं। यानी 3 फैसलों की बात आपको बता रहे हैं, 3 जजमेंट हैं, लेकिन सभी एक मत है। ये बड़ी खबर है इस वक्त की। सुप्रीम कोर्ट 370 को निरस्त किए जाने पर फैसला सुनाएगा। 3 फैसले, लेकिन तीनों एक मत है, एक ही निष्कर्ष पर है। ये बड़ी बात है।
The powers stipulated in clauses
जो आपको दिखा रहे
A, B, and C of Article 356
चीफ जस्टिस ने जो बात कही है, उन्होंने कहा है कि एक फैसला मेरा है, एक जस्टिस गवाई का, जस्टिस गवाई और सूर्यकांत, जस्टिस सूर्यकांत का है, और एक जस्टिस कॉल की सहमति वाला है। यानी कि 3 फैसले, लेकिन सबकी एक निष्कर्ष।
Any does not indicate that the union government can exercise a part of the functions of the state government, and the state government can exercise the remaining, because the suspension of the state government is an automatic consequence of the proclamation under Article 356. It rather indicates that the scope of the power exercised by the union government must depend on the circumstances for issuing the proclamation. Fourth, clauses A, B, and C of Article 356(1) grant the President independent powers. However, the power provided under Clause C is broad enough to encapsulate the power of the President to assume functions under Clause A, and declare under Clause B that the powers of the legislature of the state shall be exercisable by Parliament. Fifth, the principle underlying Article 356(1)(c) is that the exercise of power by the President must be desirable or necessary to give effect to the objects of the proclamation. The commonality in both the necessity and desirability standard is that the exercise of power must have a reasonable nexus with the object of the proclamation. Thus, the principle which runs through Article 356(1)(c) and which also guides the exercise of power under Article 356(1)(a) is that the exercise of power must have a
कोर्ट का ये भी
reasonable
कहना है
nexus
कि
to
जो
the object of the
प्रेसिडेंट
proclamation.
रूल यानी राष्ट्रपति शासन 2018 में लगाया गया, उस पर ये बेंच कोई फैसला नहीं देगी, क्योंकि उस पर किसी तरह की कोई याचिका नहीं आई थी। इसीलिए प्रेसिडेंट्स रूल जम्मू कश्मीर में, उस पर कोई फैसला हम नहीं सुनाने जा रहे हैं।